Hello, everybody, and thanks for joining us for our discussion of European employment law, specifically how to potentially fire employees in Europe. From a US or Canadian perspective, firing employees in Europe can seem quite daunting. As most people who've done business in Europe know, we don't generally have at-will employment. And notwithstanding the fact that the EU lays out a lot of different employment laws that apply across the European Union, when it comes to termination rights, they really vary from country to country. So what my colleagues are hoping to do today is give you a brief introduction to the law in a number of different countries that you may get to deal with, and hopefully demystify some of it, but on the other hand, also make you aware of when you need to take local counsel advice. So, and the good news, speaking from the UK and to promote the UK, is that the UK has the most flexible employment law rules in the world, in fact, in the Western world, outside of the US and Canada. So though we don't have at-will employment, we effectively do have it for the first two years of employment, and so that can make life relatively straightforward. Ireland, which some people would assume is very similar to the UK, is in fact a bit more restrictive. They have what's called unfair dismissal rights after just 1 year's service, and you can potentially be injuncted if you don't follow the right process in Ireland, so that can be difficult. Other jurisdictions, it changes depending upon how many employees you have. So for example, in Germany, as you'll hear from one of my colleagues, it's very easy when you've got fewer than 10 employees, then you effectively do have at-will employment. But when you have more than 10 employees, unless you have just cause and you follow the right process, it can actually be impossible to fire people. So there's a whole load of variety across the European Union. And the most important thing to bear in mind is that it doesn't matter which company is employing the person, it's where they physically work that is going to determine which laws apply. There are maybe always statutory minimum periods of notice required on termination, and often, depending on the country, there are also collective issues you need to be aware of. So some countries, for example, no matter what industry you're in, you can expect to be covered by some sort of collective agreement with a trade union, which is obviously not particularly common in the US or Canada, and is not very common in the UK either. And in other countries like Germany and France, once you get a few employees, you can expect to have a works council, and often you need works council approval before you take any decisions in relation to local employees. So I'm going to hand over now to my colleague Chris Cooper, who is going to talk to you about the UK in particular and introduce some of the principles in some of the other major jurisdictions.
Thank you, Paul. Well, the first thing to bear in mind, really, in the UK and across other European countries is that we've got a difference between contractual rights and local statutory rights. Now, from the perspective of most European countries, there is a requirement, or it would be typical at least, to have an employment agreement that will set out in some detail the terms and conditions of employment. And within that agreement, and at least in terms of termination, it would be normal for the parties to agree a period of notice of termination that would need to be given. It would also be quite common for an agreed set of circumstances similar to for-cause dismissals to be included in the contract. Local law will apply above the contract. So if local law is more favourable, then that would trump the contract. For example, if the local law requires a longer notice period to be given, then that would apply. In addition to the contract, if you are deciding to terminate an employee, it is not just a case that you would look at the employment contract, but you also have to consider whether or not local law has dismissal protection for employees. And that might be a requirement to have a particular reason for dismissal or to follow a particular process before you terminate the employee. Just looking at some of these minimum statutory rights, we've set out here a table that summarises the rules in some of the key countries in Europe, and a common theme in terms of the amount of notice that has to be given is that it will vary depending on the length of service of the employee. So, for example, in the UK, an employee is entitled to receive 1 week's notice after the first week, and then 1 week notice for each year of service up to a maximum of 12 weeks for 12 complete years. And as I said, similar rules apply in the other countries throughout Europe. It's also a common theme that throughout each country, if there's a gross misconduct or a gross negligence situation, then that would be a reason to dismiss without notice. Within the employment agreement, it is usual for parties to agree longer periods of notice than the minimum period. So, for example, for junior employees in the UK, you might agree a 1 month period of notice, or for more senior employees, you might see a 3 month period of notice. In other European countries, as Paul mentioned, there are collective bargaining agreements that apply to employees, and those agreements themselves may set out a notice period that needs to be given. As a separate matter to notice, as I mentioned, there may be a dismissal right that needs to be considered. And again, a common theme across European countries is that this right will apply after a certain minimum period of service. So, for example, in the UK, as Paul said, that was 2 years. In France, there's a requirement that an employee completes a probationary period, and the length of that period will depend on the particular role that the employee is carrying out. In some countries, like the Netherlands, those dismissal rights apply from day one, and you do need to carefully consider the reason for dismissal and the process to be followed. Once employees have got a dismissal right, you will then have to think about the particular reason for dismissal, and we're just going to go through some of the key reasons that would apply generally to the termination of employment. First of all, looking at conduct. Conduct is generally a lawful reason for dismissal across all EU countries. And looking at the UK in particular, if it's a gross misconduct situation, then that can be termination without notice. If there's minor or serious misconduct, we would usually expect there to be a written warning or a final written warning to be given before dismissal takes effect. The key issue to bear in mind in the UK is that a reasonable process does need to be followed. And there aren't any particular written rules on what that means, but generally we would expect there to be an investigation of the conduct. The employer would write to the employee to set out the allegations and give them an opportunity to consider the evidence, meet with the employee and give them a fair opportunity to respond, and then issue a decision which the employee would be allowed to appeal. I'm now going to hand over to my colleague Fabian Pomar, who's going to comment on some of the specific issues that apply in France in relation to conduct dismissals.
Thank you, Chris. As regards French law, a dismissal for conduct of the employee should, of course, result from a particular investigation, although no formal procedure is stated by the French Labour Code or French legislation. But the tricky part for the French legislation is that a dismissal for misconduct, when I say misconduct is serious or gross misconduct, cannot be sanctioned on the employee after a period of 2 months once the employer has discovered that the employee had made the misconduct. So this is often the tricky part for our clients, who sometimes discover that the employee has made something wrong and tend to wait a little too long before sanctioning the employee, and after this 2 month time limit, it's just too late, and nothing can be done against the employee. As far as the indemnities are concerned, when the employee is dismissed for gross or serious misconduct, he has no right to any notice period payments, nor any dismissal indemnities. So the only thing that has to be paid to the employee is the remaining untaken holiday that he would have in balance in the company, but no more above that.
And Fabian, can you tell us a little bit about the extent to which the employer has to follow a process before dismissal? For example, is it similar to the UK that there would be an investigation and a hearing?
Well, actually, an investigation is always recommended just to be sure that the grounds for dismissing the employees are correct, but no formal investigation process is required. The only process that has to be followed by the employer when considering dismissing the employee is to invite him to a prior meeting during which the employee can answer the grievances made by the employer, and if the prior meeting does not offer the employer the possibility to reconsider his initial process, then the employee will be dismissed through a termination notification letter 2 weeks minimum. 2 days minimum after the meeting has been set up. So obviously there is a meeting, but generally the meeting is just a procedural stage which is mandatory. But on 99% of the case, the employer does not reconsider his initial measure.
Okay, thank you. And I would like to ask Jan Kern to comment on Germany and the specific issues that apply there, please.
Yes, many thanks, Chris. Well, Germany is quite similar to the UK and France. If you want to dismiss someone for misconduct, the difference is that although an investigation and a hearing is recommended, it is not mandatory. The only thing is that it is much easier to prove in a later court proceeding the misconduct if you have given the employee the chance to explain himself beforehand. But it's not mandatory, although it is often advisable to have such an investigation and a hearing. What maybe in contrast to France is different. If you only want to fire someone with notice, then there's no time limit. We don't have those 2 months time limit. So basically you could fire someone also after 3 or 4 months after you have discovered the conduct, if you respect the notice period. However, what is usually being done if you want to fire someone for misconduct, you fire him without notice. And for such a termination, the employer has to serve the termination letter within 2 weeks after he has discovered the misconduct. And should the company also have a German Works Council, this German Works Council would need to be consulted up front, and it would need to be you would need to give the Works Council 3 days to comment on the dismissal. So effectively, you only have 11 days to make up the decision, which can be quite a challenge, especially for international companies, where it's not straightforward, where one person makes a decision. So you have to be quite in a hurry after you discover a misconduct if you want to fire someone without notice.
Okay. And Jan, to what extent is the company obliged to follow the comments or recommendations of the Works Council?
There is no obligation, and similar as in France, when you have a hearing and you have the chance to reconsider. Same thing is the purpose of this Works Council participation is for the employer to reconsider whether it really makes sense to fire the employee. But in 99% of the cases, the employer does not reconsider, and there's no obligation to follow the recommendation of the Works Council. You only have to take it into account what he has said, but there's no obligation to really follow his advice or his view.
Okay. Thank you. I would now like to ask my colleague Wolfgang Capek to comment from the Austrian and Central and Eastern European perspective, please.
Yes, thank you. Thank you, Chris. In principle, it's different in Austria and in other CEE countries as all over Europe. Austria, for example, is one of the countries in which you, in principle, do not need a reason at all to give notice to an employee. However, an employee might challenge a termination, in principle, lawfully given, for example, on social reasons, and then the court would ask you for the reason which you, in principle, do not need by law. This is a little bit a curiosity here in Austria. Of course, a serious misconduct or misconduct at all can be such a reason, and we would distinguish between an termination given without notice with immediate effect or a termination given with notice, which can still be challenged by the employee, as I say. In case of an immediate termination, you have to be very, very quick in Austria. You do not even have the 2 weeks like in Germany. If the conduct is clear, you have to decide at the best on the same day. You should have time to consult a lawyer, so it could be the next day. What you can do, and what always is advisable, of course, is to investigate what was going on. It's not mandatory, but you have this possibility. Also in terms of timing, and then also confront the employee with the findings and give him a possibility to explain things, which also gives you some days in addition to make your decision.
Okay.
In principle, it's similar in CE. However, again, every country has its own specifics. As a principle, you can say that in CE you will need at least one written warning before you can terminate an employee for the reason of this conduct. If there is an works council, yeah. Okay.
Okay. Thank you for that. I think we'll move on to the next slide, so we can get through everything on time. The next area I'd like to cover is capability dismissals, and that really, when we speak about capability, we're talking about poor performance and also long-term incapacity or even intermittent short-term incapacity. As a general theme across the EU, this can be a lawful reason for termination, although we'll hear shortly that in Germany it is very difficult to dismiss an employee for performance reasons. Just looking at the UK in particular, if you've got a poor performance situation or an ill health situation, generally what you're expected to do before you dismiss the employee is to highlight the business's concerns to the employee, give them warnings about their conduct their performance and their absence. Give them an opportunity to improve. So in the case of performance, that might involve setting a performance improvement plan. And also consider whether there's additional support that should be given to the employee. Usually a performance or capability process would last around 3 months. It can potentially be shortened, but that does increase the risk to the business that the termination could be seen to be unfair. For an ill health dismissal, it is important to consider whether or not the reason for absence is due to disability. And if that is the case, then disability discrimination rules will apply and impose additional obligations before a termination can take place. I'd like to ask Fabian now to comment, please, on the position in France.
Yes, sure. Well, under French law, the regime of these two kind of dismissal for capability, i.e. poor performance or illness, is quite similar to the UK regime. Poor performance can be a ground for dismissal, although we have not in France any obligation to set up an improvement plan for the employee, but it is obviously recommended to the employers to set up such plans, which could be rather more informal than in UK, just to gather the more evidence as the employer can to show that the employee has shown poor performance despite the efforts of the employer to support his progress, or despite the warnings that have been made on him during the past. And generally, as a practical experience, setting up a termination file or termination process for an employee who has shown poor performance can range from 3 to 12 months to have clear evidence that a termination is necessary in this respect. As regards illness or health issue, under French law, but as everywhere, I think in Europe, sickness itself cannot ground a dismissal because this dismissal would be considered as discriminatory. But the long absence of work resulting from the employee's illness can be a ground for dismissal. But under certain conditions, which are mainly that the employer has to evidence that the employee has been absent from work during a very long time or sufficient long time, and two, that the employer has an absolute necessity to replace the employee with a open-ended contract. It's not only with a fixed-term contract. And lastly, illness itself can be, under a very strict condition, a ground for dismissal if this illness is duly observed by the labor doctor, who has seen the employees twice and who decides that his health condition cannot allow him to work anymore in the company. And only in this respect can the employer dismiss the employee.
Okay, thank you for that. Jan, could you tell us a little bit about the position in Germany, please?
Yes, in Germany, it is a bit easier to dismiss someone for long-term illness. There's no formal requirement to see a medical doctor up front or something like that. The only thing is that you're not allowed to dismiss him because he had been sick in the past. You're only allowed to dismiss him because you believe that he will stay sick also in the future. And what we experience in practice is that a lot of people do recover once they have been dismissed. So it is basically a question of whether you can prove that this person will stay sick for a longer time also for the future. The second thing is performance issues, as Chris already started up front with, is a little bit difficult in Germany because you usually cannot prove to the satisfaction of the courts that some person is really underperforming. If this person is not working on a production line, and you can say everybody else is able to do 100, and this person is only doing 50, it's very difficult to prove that this person has a performance issue. So if you have this typical office worker, you can, of course, make an improvement plan, but nevertheless, it would be very difficult in the German law to prove that this person is not able to work at least with average capacities and average output. So in the end, in Germany, this really is not a good option if you want to fire someone.
Okay, and if that is the concern in Germany, would you say that the employer then has to find another reason for dismissal or reach a settlement agreement?
Yes, usually what you do is that either you transfer this person to another department, or what you do is that you restructure and then due to this restructuring, maybe this person gets fired just due to operational reasons.
Okay, thank you. Wolfgang, can I ask you please to give us some comments from the Austrian perspective?
Yes, Chris. Austria in this issue is relatively similar with Germany. I would also say poor performance is very hard to prove in practice. It's nearly impossible. Health issues can be a reason for termination. However, not because of the absence in the past, only for an expected absence in the future. So the absence in the past might only be a guideline to believe or come to a reasoning for the future. But if you give notice as an employer based on this, the employee then might challenge it at court, and then a medical doctor appointed by the court will make a conclusion if the employee, like some of the Germans, as I heard, recovers quickly, specifically during the court proceedings, or will stay ill also for the future period.
Okay. I'd now like to move on to the next slide. I seem to have a technical issue. There we go. Another key area or reason for dismissal that comes up time and again is redundancy, and this is potentially a lawful reason throughout Europe, and the term itself has different meanings in different countries, but broadly it includes a downsizing of a team or a workforce, and also the closure of a business or a place of work. From a UK perspective, if you're doing a restructuring and you wish to dismiss employees by reason of redundancy, it is a relatively straightforward process to follow. Normally it can be completed within 2 weeks, where less than 20 employees are being dismissed at the one time. And what you would usually be expected to do is follow a consultation process with the employee, whereby you will discuss the reasons for their role being at risk of redundancy, the reason why they have been provisionally selected for redundancy, and also consider whether there are any suitable alternative employment that could be offered. It is important from a UK perspective that you distinguish between the business reason for redundancy and the legal reason. So it's not just enough to explain to employees that you're looking to save costs, but you need to actually be able to explain to employees what will happen to their duties after they're terminated. For example, they will cease to be carried out or be transferred to other employees. If there are 20 or more employees that are being dismissed, then collective consultation rules apply with minimum time periods for consultation. And for 20 to 99 employees, the time period is 30 days, and for 100 or more employees, the time period is 45 days. I'd like to ask Fabien, please, to comment on the position in France.
Yes, thank you, Chris. Well, in France, when we are talking about economic dismissal or redundancy, this is the core difficult side of French law, which often frightens some of our clients. Actually, redundancies or dismissals for economic reasons are strictly defined by French labor law. This dismissal can only result from the withdrawal or elimination or transformation of the employee's position due to economic difficulties or due to a necessary reorganization of the company in order to safeguard its competitiveness. Should dismissals do not meet this restrictive definition, then there is a high risk that the dismissal would be considered as unfair by an employment tribunal. And once the ground has been found, then the employer has to comply with pre-dismissal obligations, should these pre-obligations are not met, the dismissals taken after that will be considered as unfair. And these pre-obligations are to, before dismissing an employee, which has to be considered as the ultimate and final option that the employer has to take. The employer should try and do its best efforts to try to redeploy the employees who are threatened by an economic dismissal, to redeploy them not only in the French company, but also within the whole group, which means maybe within the whole worldwide group. And should the employer lack to evidence that he has conducted this redeployment search, then the dismissals would be considered as unfair. So that's quite a heavy obligation on the employer's shoulders. Firstly, to find the appropriate ground and to evidence it, and then to evidence that all these pre-obligations have been met. And parallel to that, the employer would have to comply with a consultation process with the Works Council, where there is a Works Council, which means in companies of at least 50 employees. When more than one employee is threatened by an economic dismissal, what we call a light consultation process will have to be set up. But as more than 10 employees or more than 9 employees are threatened by economic dismissal, then we have a quite heavier process which has to be set up, because the employer has to provide a redundancy plan, which has to be validated by labor administration, and which has to be negotiated with the Works Council, which often, depending on the size of the redundancy exercise, can take several months to be set up.
Okay, thank you. Jan, could you tell us a little bit about redundancies and restructuring in Germany, please?
Yes, in Germany it's quite different from France, because the main difference is that in Germany the employer is free to make a decision of whether it wants to restructure or not. So even if the company makes lots and lots of profit, it's allowed to restructure, because that's, under German law, the business decision which the employer has to make. And if the employer says, I want to make even more profit, then it's still a good reason to restructure. So whether it's financially sensible or not, or whether the company has economic problems, doesn't matter under German law, which is different in France. And the German law, the only thing is you have to make a decision of how the tasks are in future being done either by other employees or preferable by an external third party. So if you make the decision to basically say we don't want to do any the tasks of one department, and this is going to be done by a third party now, you could give notice to all the employees in that department. There are, of course, some, and then also you don't have to give any explanation to the employees. This decision can be made by the employer without involvement of the employees. There's no consultation with the employees, nothing. If there's a Works Council, you have to explain what you are doing to the Works Council, and you have to consult with the Works Council. But once again, whether the Works Council agrees or not does not matter, as long as the employer has consulted with the Works Council. If you are making positions redundant, you have to make a social selection under German law. So if you don't close the whole department, you only transfer 50% of the tasks, then you have to make a social selection between the employees, and basically you take a look at the years of service and the number of dependents and the age, and then look at who is going to find a new job most most easily, and usually the persons who have been longer with the company are better protected.
Okay, thank you. Thank you. If we could move on to Austria and Eastern Europe, Wolfgang, could you say a few words about those countries?
Yes, in principle, it's again similar to Germany. Specifically in Austria, the employer can decide by himself if he wants to do a restructuring or not. However, the court might then see if the redundancy is really required in order to reach the tasks the employer has envisaged. If, for example, he can only set 3 people, and on the other hand, others will have to work overtime, the court can say that this was no adequate reason because the costs stay the same or are even increased. This is one possibility the court has in this instance. Further, it might be, and it often is the case, that a collective mass dismissal process is triggered, because in Austria this is already given if, for example, 5 employees out of 20 are dismissed at the same time or within a period of 30 days. This would then include involvement of the Public Employment Service and, of course, the Works Council if one exists. And if this is an enterprise with at least 20 employees, the Works Council can also go for the conclusion of a social plan, which then would increase the costs of the redundancy measures.
Okay, thank you. I'll move on to the next slide, as we're just conscious of time. But the next couple of slides that we've got, again, they're just summary tables, for you can take away with you, just as a reminder of what the rules are in some key countries. In terms of lawful termination costs, the broad themes across the EU are that minimum payments that you would expect to make are pay and benefits to the last day of employment, notice, so pay for the notice period, and a payment for any accrued but untaken vacation. Again, across EU countries, depending on the particular reason for dismissal, there may be a mandatory severance payment that needs to be paid. For example, if it's a redundancy situation in the UK, then a statutory redundancy payment would need to be paid if an employee has 2 years service or more. In the Netherlands, it's slightly different. They are introducing from 1st July 2015 a statutory formula for severance payments that will apply generally across the board, apart from for conduct dismissals. Looking at unlawful termination costs, it's something obviously you want to bear in mind when taking decisions to terminate employees. The rules do vary from country to country, so there aren't as many broad themes that we can say here. Depending on the particular country, it is possible to dismiss the employee and there would not be a risk of reinstatement. But for some European countries, it's not possible to dismiss employees unless there is a lawful reason. Or even if you do dismiss the employee, it's likely that a court would reinstate the employee if the dismissal is unlawful. So it is important to take advice when you are terminating employees to try and work out what the potential liabilities are. Across the EU, it is possible as an alternative to following a dismissal process to reach a release agreement or a settlement agreement with employees whereby they would waive their employment rights and they would waive their right to bring a claim. Generally speaking, if you want to get an employee to sign up to a settlement agreement, we would expect that you would have to offer them something more than their minimum entitlements. Although for some employees where minimum entitlements, for example, to notice are quite significant, the payment of a lump sum in itself up front may be enough. Now, looking at the UK in particular, if you do want to have a release in the UK of employment claims, it is necessary for the employee to take independent legal advice, and it's normal for the employer to pay a small contribution to costs. Depending on the payment being made, there is the possibility of a tax-free amount. I'd like now to ask Fabian, please, to comment briefly on France.
Yes, Chris. Under French law, the settlement agreements are designed as for UK for both the employer, but most of all the employee, to waive his right from any claim resulting from the conclusion or execution or termination of his employment agreement. The only obligation we have in France is that the settlement agreement can only be entered into once the termination, either dismissal or even resignation of the employee, has been notified. So we can negotiate the terms and conditions of a settlement agreement before the notification of termination has been notified, but it can only be signed, and not the day after, but sometimes maybe, generally between 3 weeks and 1 month after the dismissal has been sent to the employee. Contrary to UK law, the employee is not required to seek legal advice, but it is sometimes advisable for him to understand correctly all the terms and conditions of the settlement he is entering into, and there is no particular amount which has to be complied with, but given the social and tax treatment attached to the payment of the settlement indemnity, it is sometimes advisable to stay under the ceiling of this tax and social security exemption. For example, in 2015, so this year, the social security ceiling, under which no social security has been is borne by the employer or the employee, is 76,080 euros. So under this tax, the social security ceiling, no social security is due by the employee nor the employer. And for the tax exemption, it's
thank you. Thank you, Fabian. Jan, could I ask you to comment briefly on Germany? I'm just conscious that we are getting close towards the end, so please give us just a few comments.
Yeah, I can keep it very short, because in Germany, if the parties are in agreement, you basically sit down and sign a document. The only legal requirement that you have to meet is that you have to have a wet signature under one document, and that is it. You don't need any approval. You don't need any involvement of the Works Council, any other official body. You just sit down together and sign the document.
Okay, so that's helpful to know. Wolfgang, have you got a comment or thought that you would leave us with for Austria on settlement agreements, please?
Yes, there is no formal requirement in Austria, so you do not even have to write it down. Of course, it's advisable. If the employee asks for the Works Council to be involved, then you cannot illegally come to a settlement agreement the next 2 days. This is also a typical thing for Austria. Other than France, we have very strict rules with tax and social security over the last few years. And so in Austria, it might even be that you cannot deduct payments from corporate income tax over roughly 50,000 euros. So sometimes it's better to go on paying someone rather than pay a one-time lump sum. That's my comment.
Thank you for that.
Okay, and it's Paul here again. Just to conclude, because I'm aware that we've run out of time, do feel free to email any questions over to any of us. I think the key point to remember after everything you've heard is really to plan ahead and take advice early. And that although everyone will have a contract of employment in whatever country you're in, do bear in mind that there may well be statutory laws going above whatever's in the contract. Length of service of the employee is always important to know before you terminate, because your advisor in whatever country is going to need to know that, and also your reason for termination. Because there's no at-will employment in most countries in Europe, it would really help if you could identify the reason that you are proposing to terminate. And do consider release agreements. The rules vary from country to country. Sometimes it can be more complicated than you're used to, and other times it can be fairly straightforward. But needless to say, at Taylor Wessing, we're always happy to help in relation to any jurisdictions in Europe, and we're also very happy to promote our General Counsel EMEA help desk for US and Canadian corporations who don't necessarily have in-house lawyers in the UK or in Western or Eastern Europe. And for a monthly fixed fee, we're very happy to give you all the employment law advice you need, and advice in other areas that might be applicable to you, like commercial contracts, for example, or data privacy, all for a monthly fixed fee. And do get in touch if that might be of interest. So I hope this has been useful to you. As I say, do feel free to email any questions to any of the speakers, and I hope you'll join us on June the 10th when we have our next EMEA General Counsel webinar to talk about the different leave laws across Europe. Thank you.